Evaluation is one of the most important processes used to support teams as they plan for students with disabilities. Appropriate evaluations provide the information that an IEP team needs in order to make critical educational decisions about the child. It's essential that parents are comfortable with the evaluations completed on behalf of their child. To help make sure parents are comfortable with the evaluations completed, they always have the right to an independent educational evaluation, or an IEE. IEEs are evaluations completed by a qualified examiner who is not employed by the school. Districts are required to provide parents information about providers who are qualified to conduct an IEE. A parent may also use their dispute resolution options to address any disagreement with the school's evaluation. Parents can always pay for an IEE on their own and provide the results to the school district. School districts must consider the results of any outside evaluation the parent provides. However, that does not mean the school district must accept the findings or recommendations of such an evaluation. It means that the IEP team must consider the information along with the other data and information available. In certain cases, parents can request an IEE at public expense. Public expense means the evaluation is paid for by the district at no cost to the parents. In order to request an IEE at public expense, the parents must disagree with an evaluation done by the school. If a parent makes a request for an IEE at public expense, the district, without unnecessary delay, must do one of two things. They must either file a request for a due process hearing where they will have to prove to a judge that the district evaluation was appropriate, or if they do not file for due process, they must provide the parent with the IEE at public expense. In order for the district to pay for the IEE, it must meet the same established criteria a district evaluation must meet. It's important to remember that the district has to act without delay once a parent requests an IEE at public expense. Parents do not have to explain why they disagree with the evaluation, but the district can ask parents to explain what they do not agree with. Districts cannot use either a lack of explanation or a disagreement with the parent's explanation as a reason to delay either filing for a due process hearing or providing the IEE at no cost to the parent. Finally, parents can only request an IEE at public expense once per evaluation conducted by the district. Whether the IEE is independently funded or provided at the public expense, it must be considered in decisions about the child's special education program. Let's now explore initial consent for special education and related services. Once a child is evaluated and is determined to be eligible for special education and related services, the IEP team comes together to design an IEP that enables the student to make reasonable progress towards state standards in the least restrictive environment. Before the school district can implement an IEP or provide any special education services, parents have to provide consent. This is a one-time consent that applies to the very first IEP. If parents provide consent for services, they do not need to provide it again. And remember, consent can be given and it can be revoked later on. Revoking consent for services means the district can no longer provide special education services, and unlike consent for evaluation, they cannot use dispute resolution options to attempt to override the parents. The district has to provide parents with a prior written notice and stop providing services to the student. Remember, revoking consent does not remove the evidence of special education eligibility and services from the student record. The student will be considered a general education student and will no longer be entitled to special education services and many of IDEA's procedural protections. The student may still be protected by other laws, such as 504 and the ADA. The last piece of consent needed to review is consent for reevaluation. Districts are required to consider the need for reevaluation every 3 years, and may need to consider reevaluation earlier than that based on student needs. The purpose of the reevaluation is for the IEP team to determine if the student continues to show a need for special education and related services, and to give teams the opportunity to consider what additional evaluation information they may need to continue planning for the student. Districts do not need consent to review existing data or administer tests they give to all children. For some students, that type of information is sufficient to establish continued eligibility for special education and to plan for the student. In this case, consent for a reevaluation may not be requested. In Colorado, the district must issue a prior written notice, or PWN, to inform parents that they have reviewed existing data and do not believe additional assessments are needed. Parents then have the right to disagree and request additional evaluation if they believe it's necessary. It is when the IEP team determines that it needs additional information to plan for the student that a consent for reevaluation is needed. As with initial evaluations, if the parent does not provide consent for a reevaluation, the district may, but is not required to choose to seek dispute resolution options to override a parent's non-consent. The district does not need to obtain consent for a reevaluation if it can demonstrate that it made reasonable efforts to obtain consent and parents failed to respond. If parents simply do not respond to the request for consent, the district has to document all the efforts they made to get consent from parents, including phone logs, copies of correspondence, and records of home visits.